Good morning and welcome to the Judicial Committee of the Privy Council. Today we are hearing the appeal of Kerzner International Mauritius Holdings Limited against the Assessment Review Committee and the Registrar General. This appeal is about the procedures for statutory land valuation for tax purposes in Mauritius. Sitting with me are Lady Arden.
Good morning.
Lord Hamlin.
Good morning.
Lord Leggett.
Good morning.
And Lord Burrows.
Good morning.
Counsel for the appellant is Mr. Maxime Sauzier QC, leading Shrivan Dabi, and counsel for the second respondent is James Guthrie QC. We will take a short break this morning after the conclusion of Mr. Sauzier's submissions at about 12, at or before 12 o'clock. And I'll invite Mr. Sauzier now to begin his oral submissions.
Thank you, my lord. My lords, you will see that there are 9 grounds of appeal, and they are couched at pages 166, 167 of the bundle, and also at page 203, reference is made in the written case of the grounds, and they have been subdivided or coupled together at paragraph 13 at page 205. Before I start, my lords, you will see that there are therefore 4 main items to be debated upon. The first 3 grounds deal with the highest and the best use item. And much has been said in my learned friend's response to our written case to the word perverse, the use of the word perverse. We just wanted to clarify that when we are dealing with grounds 1 and 2, the only objection that we had was with regard with the analysis and the conclusion of the committee of the Supreme Court at page 128 of the bundle, the second paragraph. If I may read, at the end of the day, the legal issue involved is whether the committee failed to take into account all the relevant factors that have been highlighted above, so much so that it can be said its finding is perverse. We don't think it was the proper test or methodology to apply, because there was one preliminary objection before the Supreme Court. That is, the respondents did take the point that it was an issue on facts, and this was argued, and the Supreme Court came to the conclusion that there were material issues of law to be debated. And our contention is that when applying the law, there was no need for them to set a target whether it was perverse or not. A wrong application of the law, simple wrong application of the law would have been enough. So this was this is the reason which probably prompted us to make this first grounds of appeal, because we will see that the issue of law, that is the points being points of law, have not been disputed, and in fact my learned friend for the respondent did agree to the conclusions of the Supreme Court. Now let us go back to therefore the highest and best use. It is undisputed, my lords, that according to the government valuer, his evidence is to the effect that at page 18 of the bundle, that is the last paragraph, the 4th line, I read, in this zone, there is, I stress on the word, presumption in favor of a mixed use of the subject property, tourism and or other forms of complementary issues. I'm comforted with that, because the ARC, that is respondent number 2, at page 19, the 2nd paragraph, the last but one line, the land is as a hotel with a hotel building also, although it is not denied that the land can be put to other uses. So this is taken on board by the ARC. And your lordships will see that at page 205 and 206 of the bundle, I won't read through the whole paragraph, but at paragraph 14 of the written case for the appellants, we have highlighted the fact that there might have been a misconception in the analysis of the committee and the Supreme Court, because although the committee, the respondent number 2, stresses on the point that the best use value is one for 5-star hotel development, the Supreme Court speaks about a luxury and high quality development, which is an altogether different ballgame. I would think, my lords, that when we look at their lordships' conclusion at page 128 of the bundle, the third paragraph, they once more refer to the last but 2 lines. They refer to luxury and high quality development is recommended. That is, this is their, I am taking their own words. Now, what is the highest and best use concept? We agree, my lords, with the conclusions reached in 2 cases. That is, they have been referred to in tab 13, the case of Spencer and Commonwealth, and more specifically, when we look at the case of Spencer,
Mr. Sozio, we are just using the electronic bundle.
Yes.
So if you could give us always the electronic page number rather than the tab number, that would be most helpful.
I'm sorry about that. 653, my lord.
Thank you.
653. And the case of Sri Raja Viricheya is at page 660. So we agree with the concept, what is the highest and best use, but we want also to stress on one document which was produced by the respondents before the respondent number 2 during the hearing. It has been marked Annex 5. It is at page 60, my lord, of the bundle. And I think it is of interest at page 60, paragraph 6.3 is, the title is highest and best use, is defined as, if we have a look at 6.4, a use that is not legally permissible or physically possible cannot be considered as a highest and best use. A use that is both legally permissible and physically possible may nevertheless require an explanation by the valuer justifying why that use is reasonably probable. I want to stress on the words, it requires an explanation, because we haven't had the favor of being given an explanation by the valuer as to how he comes to a conclusion and how he comes to a certain figure at the end of the day. I take comfort, my lord, when looking at, in fact, what is at page 679 of the bundle. It is supposed to be tab 16 for us. The highest and best use analysis. It is, in fact, I'll read through page 679, line 6. The highest and best use is shaped by the competitive forces within the market where the property is located and provides the foundation for a thorough investigation of the competitive position of the property in the minds of market participants. An understanding of market behavior developed through market analysis is essential. So my submission is that it is imperative that there is some sort of analysis or data to back up one's thinking before the committee. And Malone, just before, I may also refer to page 680. Your Lordships will see that there is a small enclosure on the left part, middle of the page. To determine highest and best use, the appraiser must analyze data, not just compile it. As an analogy, in applying the direct comparison approach, which was the case in our case, the appraiser does not just compile a list of comparable sales from the market data. He or she analyzes the relevant sales. It is critical that a careful highest and best use analysis precede the application of the approaches to the value. So my submission is that there was a failure on the part of the government valuer to come and satisfy the committee that the concept he was backing or he was bringing before the committee was substantiated. It has been suggested, my lords, at page 210 in our written case. In fact, it is exactly what I'm saying in a summary. It is paragraph 18.5. It reads as follows: it is unacceptable to simply state that a particular use is the highest and best use without any data. So this is the main contention of the appellants today. When we look, my lords, at page 680, I was just making reference to this work. Your Lordships will see that there is a principle of 4 tests. And in our case, if we were to take, let's say, the physical possibility, is it physically possible? We know it is undisputed that there was a golf course which was an integral part of the hotel. So has the government valuer applied his mind, and has respondent number 2 and the Supreme Court, have the learned judges applied their minds to the fact that there was a golf which was an integral part of this hotel? Did they apply their minds to the legal possibility? Because your Lordships will see that at page 225 of the bundle, annexed to our written case, that there are certain sections of the law, or that is of planning and also of use, that have not, and which are essential in our mind prior to one obtaining the green light for any project, I say any project, that these sections be complied with. There has been no reference whatsoever on the part of either the government valuer or the committee, respondent number 2, or the Supreme Court. So
Mr. Sauzier, I think I may have an inaccurate page number. I thought you were taking us to page 225, but I don't think you were.
My lord, there are 2 pages 225, I would think.
Ah.
The first one, annexure 1.
Yes, that's on my page 224, if it's of any help to you.
Sorry. Yes, I'm sorry about that.
I've got it now, thank you.
Yes, I'm sorry.
That's Annex 1 to your written case.
Indeed, my lord. These are some of the legal impediments that one has to address his mind prior to obtaining any permit in the circumstances. So, my lords, yes. So I was making the maximum, the 4th point which we have in these 4 test requirements, my lord, is to relates to the cost of construction and development. Once more, we are left in the dark. I think it was on the part of the government valuer to come with some data to enlighten basically his assumption of the valuation. Now, we have said that there are merely assumptions which are relied upon by the committee and the Supreme Court. And my lord, at page 52 of the bundle, your Lordships will see that even in the report which was submitted by the government valuer, it is at page 52. I take Roman 2, which is middle of the page, line 2. He himself says in his report, within this zone, there is a presumption, I stress on the word presumption, in favor of a mixed-use tourism and other forms of complementary tourism development. These are the own words of the government valuer. So, therefore, Lords, our submission is that it was not just good enough for the respondents, at least respondent number 2, to come forward and say, this is the best use without any supporting documents or data or analysis or reports. If we were to go, my lords, just to sum up on that, at our tab 15, it is at page 674, my lords, more specifically at page 677. May I read second paragraph, 2/3 of it. It should be emphasized, however, that in the case of land capable of development, the price which it might be expected to realize under present-day conditions of strict planning control depends very largely on the kind of development for which planning permission has already been obtained, not in our case, or is reasonably likely to be given, never mentioned, having due regard to the development plan for the area. But it is essential to bear in mind the words used by Lord Denning, Master of the Rolls, in Viscount Camrose against Basingstoke Corporation. I read, even though land may be having planning permission, it does not follow that there would be a demand for it. It is not planning permission by itself which increases the value. It is planning permission coupled with demand. There is nothing of the sort in this case, my lord. They have acted purely on the word of one of the witnesses at the start of his deposition. That is, we are to is at page. The planning inspector of Flat District Council at page 17 of the bundle. He says that the most appropriate development would be a 5-star hotel. So this is the only basis on which a conclusion has been reached, and in my humble submission, this is not motivated and is wrong in principle. There was a wrong application of the basic principles of methodology in the circumstances. So this deals. We've made reference to the case of Registrar General against Antelme, which is a case that is to be found, my lords, at it is at page 631 of the bundle. Lords, yes, I appeared in this case, and the only reference which I would highlight is at page 634, the third paragraph. I read, in our present case, the burden of disproving the assessment of the appellant and establishing the correctness of the declared value appears to rest with the respondent. However, the principle that the onus lies on the taxpayer to disprove an assessment made by a revenue authority in a tax case is linked with the fact that the information on which an assessment is based is usually within the specific knowledge of the taxpayer. Where the facts are within the knowledge of the revenue authority, it may be unfair on the taxpayer to bear the onus of disproving those facts. In our case, we were completely in the dark because not only there was no evidence whatsoever which was ushered in, but there was no basis for the respondent to come to the conclusion. So this deals with the first part of my submissions, that is the grounds 1, 2, and 3. Grounds 4 and 5, my lords, deal with the open market value issue. And my lords, may I refer to the basic principles which is accepted, in fact, at page 653. 653. This is the case of Spencer against Commonwealth at page 653. Second paragraph, 10 lines from the bottom. In fact, what is the test? That is, it is not simply a willing purchaser, but it says exactly what is the test to be applied. I do not propose to read through it, my lords, but once more, at page 217 of our written case, your lordships will see reference is made to these cases, and at page 218, paragraph 28, it brings it the introduction of the highest and best use value in the direct the method of calculation. So I don't think that my humble submission is that I think that the Supreme Court got it completely wrong in Mauritius, because when we look at the evidence and at the judgment of their lordships, your lordships will see at page 131 of the bundle. I just read the first part of the second paragraph. Upon reading the findings of the committee, we are satisfied that it did not equate the market value of the property with the highest and best use to which it could be put. This is the conclusion of the Supreme Court. But when we look at the findings of the committee at page 32 of the bundle, top of the page, your lordships will see that in any case, the committee finds that the valuation only assumes the best use of the land. I think it is a blunt statement which does not, although if we read the rest of the paragraph, it is qualified, but I think that this analysis of the proper valuation is not fair in the circumstances. Now, I don't know, my lords, whether the committee were alive to the fact that there were in fact two methods which had been put forward by the valuer on the part of the appellants. First of all, there was the direct comparison method, and secondly, there was the residual method. I find it strange that the committee, at first instance, that is at page 33, middle of the page, line 19, they come to the conclusion that both valuation exercises carried out by Mr. Ramlacan, valuer for the appellant, are not appropriate to determine the open market value. I think they got it wrong there, lords, because even the government valuer went through one of the methods which was applied by our valuer, that is the direct comparison method. But there was the introduction of the highest and best use, on which point they differed. I think it was a wrong assumption once more on the part of the committee and the learned judges. So this deals with the second part of my submission, my lords. The last part of my submission, in fact, we are going to be much shorter than expected, concern the comparables and the discounting rates. I might lump both of them together. Now, my lord, it is agreed that in this case, the focus was on the direct comparison method, and at page, we totally agree, my lords, with the definition of the test to be applied. It is to be found in the case of Marklands against Virgin Retail. It is at page 617. More specifically, paragraph 9. How does normally valuation proceed? It is by way of analogy, and going through this, the first paragraph, we totally agree with the concept as highlighted. Now, there are obviously a number of things which have to be taken into consideration. That is, first of all, the location, the size, if there are any restrictions. In our case, the frontage of the sea, the use of it, and your lordships will obviously see that there have been two lists of comparables as they have been described. One of them, which was put in by the appellants, that is their valuer, and the report of the valuer is at page 46 of the bundle. There is no need for us to go through all. That is very, very lengthy, but no need to go through all the reports. But your lordships will see at page 49, there is a list of 3 plots of land, and just on top of this list, your lordships will see a paragraph which is marked market considerations. And in fact, there is mention of 2 plots of land. In fact, these 2 transactions are the 2 transactions which have been earmarked by the valuer of the appellants. And these transactions, I'll come to them later on in the final part of my submission. That is 2 golf courses, one Le Morne, which is situated in the southwest of Mauritius, and the other one, Constance, which is next door. That is a small coastal road of approximately 15 feet or 20 feet, separating the present place, the present land, and the Constance golf course. Now, on the part of the respondents, your lordship will see that the list of comparables is to be found at page 53 and 54. They are the same, 53. It is accepted, my lords, that the committee, as well as the Supreme Court, they have gone through all the title deeds, they have gone through all the comparables. I'm not saying that they failed to take into account, they've been through all of it, but my submission is that they were wrong in applying the principles. Now, it is agreed, my lord, as far as the size is concerned, that there is no comparable that can match. No comparable. It is an essential part of the valuation, and I am comforted in my submissions, my lord, if I make reference to a Mauritian court, a Supreme Court judgment in Mauritius, which is the case of Nazir against Board of Assessment. It is at page 2. I'm sorry, it is at page 623. If we turn to page 626, your lordships will see that there is an analysis as to the comparison of plots of land of 70 toises or 7 perches, or against a plot of land of 720 or something like that. So in fact, 10 times bigger. And their lordships in their analysis will say that it is impossible for any valuer to have plots of land of 10 times bigger plots of land to be compared to a smaller plot when having a valuation. So in this case, I'll come to it in the last part of my submission. A plot of land 10 times bigger was found to be totally inadequate. In our case, the plot of land which is being referred to as the only reference is 34.5 times smaller than the plot of land which is the subject matter of the transaction. So I think it is a far cry from the case of Nazir, where 10 times was held to be totally inadequate. In our case, it is 34.5. But even if your lordships were to say, we can go over that specific hurdle, what about the prices? What about the valuations in both reports which have been filed? That is Annex 3 and the 2 reports, that is from the government valuer and from our assessor. That is, the first one is at page 46. That is the report of Mr. Ramlacan. And your lordships will note, I'm not speaking about the 2 golf courses. I'm speaking about the 3 plots of land, which are page 49. You will see, my lords, that the price range per acre in 2006-2007, they range from 9,200,000 to 19,800,000. So they range from 9 to 80 to 90. In the annexure, in the report of the government valuer, your lordships will see that the range, the maximum is 36 million per acre with a sea frontage, with the exception of the plot which has been highlighted by the Supreme Court. I'll come to that, 72 million per acre. So the only one transaction which is more than double all the plots of land is the plot of land of 72 million rupees. And this is the plot which has been earmarked by the Supreme Court to be the value. Now, my lords, you will see at page 56, because it brings some water to the valuation, at page 56, annexure 2A, you will see top of the page, Saint-Gérand Hotel. This is the plot. This is the hotel we are talking about. It is now the one and only Saint-Gérand. And TV 4094-51 is in fact the sale transaction of 72 million. It has no sea frontage. And according to Mr. Ramlacan, it was a special sale because it was a small hotel within the precincts of Saint-Gérand Hotel. So this was discarded by the Supreme Court and by the ARC because they said that there was no sufficient proof. Now, my lords, let us be factual and simple. This transaction of 72 million rupees occurred in 2000. Our transaction occurred in 2007. If we look at all the valuations, that is the reports which have been produced, none of them reach half of the figure of 72 million rupees. When Mr. Gibaudan, that is the expert on the part of the respondent, was being cross-examined by my learned friend, your lordships will see at page 21 of the bundle that according to the government valuer, the price of 72 million was indicative of the market price in 1999. And I read further. He did not agree that his comparables, which came after, would show a drop in the price of land if the one of 72 million rupees in 1999 was indicative of market value. This is quite aberrant, as we would say, because if one was to sell one plot of land at 72 million in 1999, in 2006, 2007, one would expect the price at least, I say at least, to be at par, not to drop by more than half. So it is obvious for any person going through the record that the transaction which was highlighted and selected by the court was a special sale transaction, and that it could not by any stretch of imagination be the standard from where to value this present transaction. Now, my lord, where we've got a problem also is when we look at the report of the government valuer. This is at page 53. He comes to the conclusion, after having drawn a list of 4 plots of land, it comes to the conclusion That at the almost last line, but one. He values 1 acre at 40 million rupees without any explanation. He makes an allowance of 15% for size only. So we come to 36 million, something like that. So it comes to a figure of 1.1 billion rupees. This is why we went before the tribunal. Now, so the basis on the part of the government valuer is 40 million less 15% for size. That is all. No explanation. When we go before the court, the learned judges, they seem to discard the report of, before the tribunal, the ARC seems to discard the report of the government valuer because they come to the conclusion that the starting point is 72 million. Why do they discard both Mr. Ramlakan and Mr. Djibouden? And they start at 72, not 40. We say it was much lower, but they start at 72, and they give discounts. They apply discounts, 50 at page 36, your lordship will see. They give special discounts for size, for the frontage, for the uneven shape, and I don't know what was the test or what was the standard for irregular shape for the sewage plant. 15% for the frontage, 10%, 50% for the because it is a large plot. If they had applied it to the 40 million, we would have understood maybe, but they applied it to the 72, which was not even taken on board by the government valuer. So this is simply to say that the ARC went wrong on that score. I think that the method of application of the test was wrong altogether. Now, Lords, coming back to the two proper comparables, for me, there were two, and they were listed in the report of Mr. Ramlakan. Now, that is the two golf courses. There are not many golf courses in Mauritius, and the transactions with regard to golf courses, it's very scarce. So there have been two. One of them is the Le Monde, and you will find it, my lords, in at page 49. Le Monde is admittedly, my lords, it is in the southwest of Mauritius, and the golf course we are talking, present transaction, is in the southeast of Mauritius. But both of them are facing the sea, except that the Le Monde one has got a much better frontage than the one which is subject matter of this transaction. Same size, same use, with the exception, I'm sure that my little friend will highlight that according to Mr. Ramlakan, that is the expert for the government, there was Mr. Djibouden, there was a restriction, that is, it could only be used as a golf course. This is not to be found in the report of Mr. Ramlakan at page 49, because you will see, my lords, at page 49, under market considerations, line 5, the excision permit attached to the deed mentioned that the land is presently developed as a golf course, and therefore the excision is for touristic purposes. So this is the explanation which is given by Mr. Ramlakan, and the price which was approved and undisputed for the sake of the record is that at the end of the day, it was sold on the basis of 1 million rupees, 1,093,000 per acre, compared to 72 million per acre in this present case. So there is some sort of, admittedly, my friend might say the location is not the same. Mauritius is not very big, and one is in southwest, one in southeast, but the use of it, and I stress that the Monde golf course is next to a 5-star hotel, the same as Saint-Géron Hotel. So the concept of the application was wrong in all circumstances. Now, Lords, the Constance sale, that is the second golf, there are two negatives for the appellants. One of them is that it is 102 acres, that is 3 times bigger, not 34 times, but 3 times, admittedly. Secondly, it was in 1995, that is 5 years prior to the transaction of Le Mode, and it is also, there is no sea frontage. My friend will probably know the place, and it is just 25 feet apart, but it is a bigger place, and it was sold in 1995 on the basis of 389,000 rupees per acre. So we are very, very, very far from the value which has been computed by the government valuer on the assumption that there could be a development for a hotel there. Now, my lord, this brings us to the last part of my submission, and my lords, I don't know at the end of the day. I was under the impression when I started going through this case years back that the only approach would have been the direct comparison, because it's normally considered to be the best approach. But if we apply, my lords, the test which was singled out by their lordships in the case of Nazir, I referred to that case earlier on at page 626 of the bundle. If according to you, my lords, at the end of the day, all the comparables are not at par with the transaction that we are dealing with, it would seem that both respondent number 2 and the Supreme Court failed to apply their minds to the proper test, that is the residual approach, the residual method. This is a method which has been brought forward by Mr. Ramlacan, and it is in fact to be found at page 50 of his report. He was not cross-examined at all on this aspect or this possibility. And your lordships will see that the principles enunciated in Nazir are on all fours with this approach on the part of the appellant's valuer. And there is a table which shows the acreage of the land in square meters also, and all the expenses, and it is explained how it works. And at the end of the day, when we turn to page 51, your lordships will see that the valuation which is ascribed per square meter equals 19 million rupees per acre. That is the highest in the table of Mr. Ramlacan. I just want to draw your lordship's attention that at page 16 of the bundle, that the committee got it completely wrong, because when they speak about the residual approach, I just read, my lords, for the sake. The residual approach used by Mr. Ramlacan admittedly gave a rate of 3.6 million per acre. This is wrong. This is totally wrong, because when we look at page 51, it is, when you look at the top of the page, your lordships will see that the price per square meter is 4,698, which is 19 million, not 3 million per acre. So the concept is wrong, and the calculation is wrong. So I think that there is a failure once more on the part of both the respondent number 2 and the Supreme Court to have applied their minds properly to the fact that if this doesn't tally, at least this could tally. So, my lords, I've done with my submissions, much shorter than expected. If your lordships have any questions, I'll be glad to assist.
No, it doesn't look like it, Mr. Sauzier, and thank you very much for your concise submissions. They're always a delight to receive.
Thank you, my lord.
Unless you want to start now, Mr. Guthrie, maybe we should simply take our short break rather early this morning.
Well, as you wish, my lord. Let's do that.
I think let's take our short break. I make it 15:15 now, and let's resume again. We could take it slightly longer than usual, I think, because we are so much ahead of time. So we'll resume again at 25 past. We'll take a 10-minute break. Well, welcome back to this morning's hearing. Mr. Guthrie, we'll now hear your submissions, please.
Thank you, my lord. Well, I'm also not planning a long campaign, my lord. As you know, the Registrar General's position is that the appeal should be dismissed. You will have noted that the committee's decision did not only raise the liability of the appellant to pay tax, it also considerably reduced the original assessment, which was made by the Registrar General. But the Registrar General has reached the view that there isn't any reasonable basis for challenging the Assessment Review Committee's decision, as it has subsequently been endorsed by the High Court. And I don't think it's yet been mentioned, but your lordships will have noted that the position of the Assessment Committee is that it wishes simply to abide by the decision of the board, and it adopted that position also before the Supreme Court. I can give you the reference to what is called a notice to abide, which is at page 65 of the record.
Thank you.
My lord, if I turn to the points made by the appellant, what is described as the main argument is that the committee adopted the wrong approach by relying on the highest and best use for the property. We would respectfully suggest that that simply disguises or moves the argument away from what were in reality much more straightforward issues, which contained a substantial element of fact. In ordinary language, the principal issue before the assessment committee was whether the property should be valued on the basis that it was capable of development as a hotel, or whether it should be valued on the basis of its present use as a golf course. And the first part of that question, at least, whether the land is capable of development as a hotel development, is indeed a straightforward question of fact. There was plenty of evidence to that effect. In our submission, there should really be no issue about it. And perhaps I could begin by reminding your lordships that the Registrar General's case, both that the land was capable of development as a hotel and that it should be valued on that basis, was made clear from the outset. And I could ask you to go to page 52 of the bundle. That is the assessment report of the government valuer, Mr. Jupiter. And if you could just note the date, that was the 10th of June 2009, so some years before the hearing by the committee. And it made it absolutely clear what the Registrar General's position was. And you'll see on page 52 that the property is described, a little Roman 1, a prime site located along the coastal road between the Saint-Geron Hotel and the Belmar Plage Hotel complex at Belmar. And the point is then made that the Flat District Area Council is part of the Eastern Tourism Growth Zone, etc. Various characteristics of the land are described, and then the conclusion under Roman 7, as per guidelines of the international valuation standards, the concept of the highest and best use is a fundamental and integral part of the market value considering the location, size, attributes, and neighborhood of the subject property, its highest and best use would be a hotel site. That was the Registrar General's position throughout. At the hearing, Mr. Mohammed Ali, who was the planning inspector of the Flak District Council, gave evidence, and you'll see that at page 17 of the bundle, that is summarized in the conclusions or the case as stated by the committee. As follows, he said, the location of the subject property is such that the appropriate development would be hotel development, as mentioned in the National Development Strategy, and is highlighted in the outline scheme of the Flak District Council. When it came to the government valuer giving evidence himself, he gave evidence in accordance with the report that I've just shown you. We needn't go to it in detail, but he was cross-examined at pages 21 to 24. Again, I don't think it's necessary to take you to that at any length, but it was not suggested to him that the hotel development was impossible or impractical. And indeed, the appellant's own valuer, Mr. Ram Lacan, at page 14, accepted effectively the possibility of development as a hotel. If we look at the last part of that page, we see, regarding zoning, the applicant's valuer explained the subject property is in the airport noise constraints buffer zone. It is termed as golf course, and it is in the tourism growth zone. Then Mr. Ramlakan stated it is partly in the growth zone. Admittedly, in the tourism growth zone, higher uses can be contemplated. This is whether the subject property can be granted a permit for residential development or not is considered speculative. Mr. Ramlakan admitted that under the National Development Strategy and Policy of 2003, the type of construction which is recommended for land such as the subject property is luxury and high quality hotel development. And he goes on, the next paragraph, the witness agreed that the golf course will not have the same value as a resort site. Really, there was abundant evidence for the committee to decide that the appropriate basis for valuation would be as a hotel site, because the site was capable of such development. Just as that fact was made clear from the outset in Mr. Jubadan's report and was substantiated by the evidence, the basis of valuation was also made clear from the outside. As I've said, in the report, we see at page 52, the sentence I think I've already had, as per guidelines of the International Valuation Standards, the concept of the highest best use is a fundamental and integral part of the market value. And this is a quotation from a document which was attached to the report itself, so before the parties since at least 2009, and has been referred to already by Mr. Sezier, Annex 5. If one goes to page 60, one sees the highest and best use approach being explained. There are two passages on that page. Under 6.3, the most probable use of a property which is physically possible, appropriately justified, legally permissible, financially feasible, and which results in the highest value of the property being valued. and at 6.7, the concept of the highest and best use is a fundamental and integral part of market value estimates. We would submit there's really no room for suggesting that there was some confusion between the highest and best use approach and the market value approach. It was accepted on all sides and endorsed by the committee and the High Court that the highest and best use is one of the elements which is useful in establishing what is the market value. There was no confusion at all. You can see that most clearly in the passage of the judgment of the Assessment Review Committee, or the decision of the Assessment Review Committee at page 32. It's the top half of that page. If one begins on the second line, in the present matter, the question is not whether the applicant will actually develop the land into a hotel or whether he will continue to use the land as a golf course. The real question is whether the declared value of the subject property reflects the open market value of the property at the material time. To determine this open market value, the valuer has to consider the highest and best use of the subject property, which is of an extent of, etc. It is clear that using the line of a golf course is definitely not the highest and best use for such a property with such characteristics, irrespective of the fact that the buyer may continue to use the subject property as a golf course. It is true that a golf course is already a developed land which has required investment, but as rightly pointed out by the government valuer, there is no indication as to the income of the golf course can generate. In valuing the land, the government valuer is right not to take into account any interest Le Saint-Geran Hotel may have in the golf course. The planning inspector of the district council himself has stated before the committee that the best use the land can be put to is a hotel development, and in these circumstances, the committee has no doubt that the highest and best use for the market property is a hotel development, although the land is already a golf course and may continue to be used as a golf course. Well, I turn, Mr. Sauzier suggests.
Sorry, just before you move on, Mr. Guthrie, can I ask a question?
Yeah.
Am I right to understand the committee took it on the basis that it could certainly and without any possibility of doubt be used as a hotel? That was their assumption.
Well,
you might expect that there would be some discount or uncertainty in this sort of exercise, given that you're going to have to get permission and even if it looks promising as a development.
Well, the evidence...
market value, you normally expect some sort of discount, but the committee seemed to have just proceeded on the assumption that without fail, it can be used as a hotel. Is that right? Well,
that was the evidence of the planning inspector who would have been the person responsible, I mean, the uncertainty was really very difficult to see where it came from, because here you have a seafront property between two hotels, to which all the evidence is that it could be developed as a hotel. I'll come on a moment to the points your lordship has raised. I think that's summarized, and I think Mr. Sauzier referred to this in paragraph 17.1 of the appellant's written case, which we find page 207, I think.
Sorry, while we're going there, just one more question, Mr. Guthrie. 14 years on, is it now a hotel as a matter of interest?
I'm afraid I have no idea. Well, I'm just trying to think what would have happened. I may get some instructions on that over the WhatsApp group, but Mr. Sauzier has raised his hand.
Yes, in fact, your lordships will see that only 20% of the shares were sold in 2007. And then there was a subsequent sale of the 80%. It's now being developed in 2021 into a residential complex, not a hotel.
Oh,
thank you.
I don't think, with respect, that can probably help us as to the result in the present case. But as I've said, I was going to take you to paragraph 17 of the which is the objection, and I think covers the point made by my Lord Legate, saying that it is impossible that in order to adopt the highest and best use, one has to look to see whether it's physically possible, appropriately justified, legally permissible, and financially feasible. My Lord, there doesn't seem to be any real issue that it was physically possible on the basis that that was not raised as a difficulty by anybody at the hearing. And indeed, we know that it's a seafront property of a certain size between two hotels. So one would have thought that if there was some impediment, it would have been raised by somebody. Whether appropriately justified, that would seem to be covered by Mr. Muhammad Ali's evidence, which we find at page 17 of the bundle. He says boldly in terms, the location of the subject property is such that the appropriate development would be hotel development, as mentioned in the National Development Strategy and is highlighted in the outline scheme of the Flack District Council. But I suppose part of the answer to my Lord Legate's question as to whether there was an element of doubt in the matter is that that was a question of fact which was within the purview of the committee. And insofar as it's a question of fact, it's really out with the scope of an appeal which is limited to a decision which is erroneous in law. The next qualification, which my learned friend referred to as to whether it was legally permissible to develop into it, to do it in this, to adopt that approach. It's a page, we look at page 22, where we see Mr. Jibadan giving evidence. This is again, perhaps if we start at page 21 at about line 28 towards the bottom, the witness, Mr. Jibadan, stated that he has considered the highest and best use the subject property of 34.5 Appellant can be put to. In the present case, this highest and best use could only be hotel development. As regards the residual value method of valuation, it depends on what can be done in the land. In this respect, Mr. Ramlakhan has assumed a residential parcelling. Mr. Jibadan has not considered any other possible use apart from the construction of hotel buildings. He based his valuation on just this one use. He considered that whether a development permit can be obtained for a hotel on the land is not an issue because the property is within the growth zone and such a permit can be obtained. Admittedly, the subject property forms part of the airport noise constraint zone, but this should not hinder hotel development, according to him. The officer of the district council has stated before the committee regarding a hotel development being the best and highest use of the subject property. To decide what the highest and best use, the government valuer stated that he did not consider other possible uses. There was no risk of a permit not being obtained, according to the district council, which I would respectfully submit justifies confidence of the committee, if you like, that there was no real doubt that development of a hotel was the appropriate highest and best use for the property. Finally, that's the legally permissible point. The final point is to financial feasibility. As I've said, the prospect of hotel development had been on the cards and squarely before the parties. Since at least Mr. Jibadan's report in 2009, if there were financial impediments to it, one would have expected them to have been developed at least at some point during the hearing, if there was some financial constraint which would have prevented that, one would possibly have expected some evidence to have been led by the appellants to that effect. And you may have noted that one of the witnesses, one of the two witnesses who were called by the appellant at the hearing was the company's accountant, Mr. Wong. And he presumably would have been the person in the best position to say, well, this is not financially not on the cards, because the amount of money it would cost to develop the hotel would make it a financially improbable proposition. But he didn't say anything of the sort. And indeed, there was no cross-examination of any of the respondents' witnesses to the effect that development of a hotel would not be possible. There were certain submissions made that it would be at the end of the day, but there was no evidence to the effect that development of a hotel at that spot was not a viable proposition.
But don't they say the onus of proof was on you to prove the positive?
Well, they say the onus of proof, but there must have been an evidential burden on the. One might suppose that a beachfront property between two substantial hotels, which are operating in Mauritius, almost went without saying that the appropriate development would have been a further hotel development. But
was there any evidence as to the capacity of the hotels and whether they were operating as full or not?
Well, no, but the evidence was clear from the evidence I've just taken to you two was clear that the hotel development would be appropriate and not, and indeed encouraged by government policy.
Indeed, but that doesn't solve the financial problem, does it? That's about physical use of the location. And of course, there must be some risk that the development scheme promoting tourism might change, especially as everyone would have known about.
But surely, with respect to the onus of proof, the government valuer, the respondents must have satisfied the so to speak, the evidential burden on them. They made it quite clear that they considered that was appropriate. They can hardly be expected to do the respondents' sums for it in relation to whether it would be financially viable to open it as a hotel or not. If the appellant knew that that was the respondent's case and it wished to rely on the fact that this was financially not on the cards, and so consequently it was not appropriate to value it as a hotel site, then they should have called some evidence to that effect.
Yes, so it's you say, well, there wasn't really an onus of proof on you.
But, well, there was an evidential burden, I would have said, on those who suggested that our proposition, which would appear to accord with common sense in the land between two hotels, was suitably developed into a hotel.
So an evidential burden which was provoked by the evidence that it could be zoned for use as a hotel.
But not only that, but it went rather further than that in the passage that I've just read to you. The highest and best could only be hotel development. And indeed, perhaps I can repeat at this point, but surely that whether or not that was the case is largely a question of fact, is it not? And a question of fact is not a question which which is within the scope of the appeal from the committee to the High Court.
But a question as to burden of proof might properly be a point of law.
Well, yes, if the burden of proof was the burden of proof as to whether or not it was financially viable, I would have suggested that that had been discharged by the evidence which was given by the appellant, but there would then arise an evidential burden on the response to say why the proposition was wrong.
But obviously, in working out whether it was financially viable, you'd have to look at what the bookings would be for this hotel. in future years to see if you had a stream of income to pay off the finance costs.
Well, I would respectfully have submitted that that was something which, if the respondents had thought it was a worthwhile exercise, the appellants had thought it was a worthwhile exercise, they could have done. It could hardly be expected that the Registrar General to produce a lot of evidence about the likelihood of the bookings in the future.
Yes, and without that, it's not really, without being satisfied, the ARC being satisfied, the committee being satisfied, that it's realistic to develop as a hotel, then of course it wouldn't be right to take the highest and best value.
Well, it's quite plain from their decision that they were satisfied that that it was a realistic possibility, because they said as much.
Yes.
I think at page, is it at page 130? Sorry, page 30.
I think that follows from the passage you were just reading, wasn't it?
Yes, it's not the only passage in the judgment. I wasn't going to take you to the whole of it, but for example, at page 35, the committee will here point out that the government valuer has rightly considered that the highest and best use for the subject property is a hotel development, as was confirmed by the representative of the district council.
But that's on the basis of the zoning evidence, of course. Yeah.
Yeah.
Thank you. I think we know where the point is. Yeah.
Yeah. Well, I was going to add at this point, having gone through the objections raised by Mr. Sauzier, physically possible, appropriately justified, legally permissible, and financially feasible. A general point that we can see that the practical issues which were considered to be relevant, and perhaps they didn't include the financial viability, because that wasn't simply assumed as not being a matter of a great contention, because no evidence was called on either side about it. There were considerable consideration of practical issues which might have been impediments to the development. At pages, I think it's at pages 24 to 25, one can see the various submissions being made by Mr. Sauzier. The golf course would have to be destroyed, etc. The opportunity cost of constructing new hotel buildings, etc. Those are all matters which were considered by the committee. And then one can see at page 31, for example, the consideration being given by the committee to the objections which could be made. There's a question which was raised, and I think is no longer relevant, as to what the Prime Minister's office had said. One goes on to page 33. One sees the committee has come to the conclusion the government value was right to consider, etc. It was suggested on behalf of the applicant that the sea frontage of 250 meters is not appropriate. The committee finds that this averment was not put to the planning inspector in any case, the latter being aware of the characteristics of the site as he has been on site, has expressed the view that the appropriate development would be a hotel as per the National Development Strategy and as highlighted in the outline scheme of the Black District Council. And then various individual matters, such as the presence of a sewage treatment plant, etc., they are gone into by the committee and decided. So the conclusion of the committee that the property should be valued on the basis of possible development as a hotel site was, in our submission, entirely reasonable and appropriate. Indeed, the evidence all pointed in that direction. The Supreme Court endorsed that decision. I've made the point in my written case that insofar as these decisions contained elements of fact, they come within the principle that your Lordship's board applies as to concurrent findings of fact in the courts below. I've given a reference to that in the written case. It recently endorsed in a case called Byers and Chen, which I think was delivered.
I think you can take it, Mr. Guthrie.
Yes, that you're aware of that, yes. Yes.
Well familiar.
Well, it does come into play in the present case in our respectful submission. Here we have the specialist tribunal set up, endorsed by the Supreme Court, and in a particularly good position to make the assessments it did. Well, may I turn then to, I was going to ask your Lordships to look at a particular passage in the Supreme Court judgment of page 126, where the court refers to the arguments which are made, and I've been considering just now as to whether the development was probable, etc. Counsel put into question whether the construction of a hotel on the land was probable. His argument was to the effect the property was part of the golf course of the hotel that was next to it, therefore unlikely that another hotel would be put out close to Le Saint-Geron. Moreover, the existence of a sewage plant in the front of the land may be an impediment to the development of a hotel project, both aesthetically and health-wise. Also drew attention to the fact the land was in the noise buffer zone. As the physical possibility of a hotel project, he submitted land has an irregular shape which may not be conducive to the construction of a hotel building. Added to that is the fact the frontage of the land is only of an extent of 250 meters, which renders a hotel exploitation rather unlikely. The senior counsel also took issue with the financial feasibility of a hotel project on the land in Lighty. His argument was to the effect, etc. Finally, concerning whether a hotel would be legally permissible. I would respectfully submit that all those issues are, in fact, issues of fact, and they are issues which have been decided by both the tribunals below, and that there is no reason to doubt that the decisions were correct. But in any event, they come within the principle which I've just alluded to. The physical possibility of a hotel project and the financial feasibility, those are questions of fact, not questions of law. Sorry, my lord.
But surely, Mr. Guthrie, it wasn't for the Supreme Court to make any findings of fact. It was simply to consider whether there had been an error of law. Well, the only fact-finding tribunal must be the ARC.
That's correct, my lord. But insofar as it endorsed the findings of the lower tribunal, then that must mean that there are concurrent findings of the courts below. But I take your lordship's point. But they could simply have said, I suppose, well, we won't go into that because those are questions of fact which have been decided against you. But they didn't. They said what I've just read out to you.
Well, they said that the ARC had evidence to support the findings that they made. Yeah.
Well, indeed. But when that is usually the way, isn't it, that an appellate court endorses the findings of fact of the court below. Well, may I turn to the comparables issue, which in our respectful submission is a very short point. If your lordships accept that the committee was right to accept for that the basis for valuation was as land with the potential for hotel development, then the comparables which were put forward by the appellant were of no use because they clung to the view that the land was to be valued as a golf course. And as the committee pointed out, and the High Court pointed out, the land at Le Morne and Constance were for golf courses only, without the potential for development, and indeed without seafront, etc., and so were unsuitable for that reason. And we would submit, as a result, the comparables were bound to be rejected, as the High Court did reject on page 134. That's the paragraph in the middle of that page. The committee rejected the approach taken by the appellant's valuer on several grounds, but mostly for the reasons that the Le Morne and Constance properties could not be used as proper comparables, since those properties were golf courses which had no sea frontage and were not freehold land. The appellant's valuer assumed that the subject property would be used as a golf course, whereas the evidence adduced before the committee suggested that the subject property could be put to higher use. The Supreme Court also endorsed the use of the comparable, which is reference TV 409451. Perhaps I could just say that the committee was, with respect, stating the obvious when it pointed out at page 39 that it would be difficult to find an exact comparable to be used. They say on page 39, comparable TV 409451 was not exactly similar. It is usually very difficult to find two properties with exactly the same characteristics in the same region. This explains why adjustments have to be made. But there was a good reason to use the comparable concerned. On the same page as we were just looking at, 134, the Supreme Court points out that that was the sale of one appellant of freehold land with a sea frontage. It was located next to the Saint-Geron Hotel, so that could be seen as a plus from that point of view. It was transferred for 72 million per appellant. Committee took into account the big plots of land, etc., and gave 50% discount for that. My Lord Legate.
What was the rational basis for disregarding the government valuer's valuation, and in fact take a starting point rather, the 40, and taking a starting point almost double?
Lord, I think there was well, I'm about to say I'm not sure I can immediately answer that question, but there was I didn't take the reference, I'm afraid, where Mr. Sauzier was, so to speak, metaphorically on his feet to that to that part of the decision.
Isn't it because they rejected the other comparables which the government value had?
Yes. Yeah. They rejected the other ones, one of which they pointed out could not be used because it was the date was wrong.
Well, why can't you use one that occurred 2 months later, which otherwise, at least as a cross-check on whether it's right to take a starting point twice that, which was 7 years ago?
Well, I see what your lordship, I see the force of what your lordship says, but I don't, with respect, think that that invalidates the appropriate use of the one they did use. I mean, it was a difficult exercise. I mean, your lordships can well take on board the fact that Mauritius is not a very big place, and comparables are going to have to be used with a good deal of circumspection. The complaint which is made in relation to that particular comparable and the discount which were adopted by the board, we would respectfully submit that, well, first of all, the choice of comparable is again largely a factual matter. And so far as the discount issue is concerned, it's unfair to suggest that the discounts which were made by the committee were arbitrary or unexplained. In fact, on page 36 of the record, you can see a quite lengthy explanation for the calculation of discounts. But the real point surely is what the Supreme Court said about that, is that you entrust the valuation and the assessment of the valuation to a panel of experts, and you have to trust to their judgment as to what is appropriate.
But you expect some rational basis, though, for the decision. And what was the rational basis for saying you could use a plot that was 36 times smaller and discount that by 50% to come up with an appropriate value for a plot 36 times bigger?
Well, it was.
It just looks like a number taken out of the air.
Well, it was the best they could do, given the material which was before them, and there was not no rationale for using the plot. It was exactly the right place, one might say, next to the Saint-Geron Hotel.
Well, they ignore all the leasehold plots because they're leasehold, not freehold. But they say, because they say that's a different market. But why doesn't the same apply to plots that are 36 times smaller?
Well, they do make a substantial discount for the fact that it's 36 times smaller.
But they don't give any base methodology for that. You might expect some comparison of based on size of plot to say that you discount by a certain percentage if you.
Well, that assumes that there are comparisons which could be put before the board, before the committee, which you could take into account. But quite apparent, it's apparent that the existence of comparables was severely curtailed by the fact that there weren't any.
But what was the basis for disregarding the apparently direct comparable? Of what was the justification for ignoring one that was half the amount because it was 2 months later as opposed to 7 years earlier? Or whatever it was, a year later.
I think they say they do, they not, why they're doing that. I'm trying to find the place.
Well, they say you can't take account of subsequent information. Yeah. Why not, as a matter of law?
Well, Lord, I've already accepted that it's possible that your lordship has, that it could be used as some kind of cross-check. My lords, I'm not sure that there's anything that I want to add. I said I was not going to be very long. Your lordships have the issues. I mean, we submit that fundamentally these were matters for the committee. The committee's view has been endorsed by the Supreme Court, who are in the best position, or the committee and the Supreme Court are in the best position to do these, to make these decisions. Really, that is that there is no basis on which your lordship should interfere with the decision that the committee made.
Well, thank you, Mr. Guthrie. Unless my colleagues have any questions, any further questions, it seems not. I'll say thank you very much for your submissions, and we'll hear from Mr. Sauzier in reply.
Very briefly, my lords, the only point I wanted to make is with regard to the best use. I think her ladyship, Lady Harden, did put a question, and if I refer to the judgment of respondent number 2 at page 22 of the proceedings, the fourth paragraph, 7 lines from the bottom, Mr. Gibaudan admitted that his assumption that the highest and best use would be to put up hotel buildings had not been tested, but he maintained that the location of the subject property and the other characteristics would support his assumption. Once more, I think that what was said earlier at page 680, when I made reference to page 680, the small caveat on the left of the page, is that it was for them, because for them to come forward with specific data before the committee, because it is a committee where we depone first, and there is no exchange of pleadings. There is simply the report which is exchanged. And the only report which was before the committee was the 2 reports of Mr. Ramlacan and Mr. Gibaudan. This is the whole, the pleadings between parties. So there was nothing to suggest. It was up to them to come forward with a suggestion that it was financially possible, feasible, and physically possible. So this is what I have to say to sum up as far as we are concerned, the appellants.
Thank you, Mr. Sauzier. Well, that concludes the submissions. The board is most grateful to counsel on both sides, and indeed your supporting teams, for the carefully presented written and oral arguments and for your helpful response to the board's questions. And we will now go away and consider our judgment in the matter, and we will let you have it in draft as soon as possible. Thank you. The board is now adjourned.
Thank you.